Article 11. This is the condo conversion bylaw. This was a part of the Board of Selectmen's goals for the year to be able to bring this forward. So Massachusetts in 1983 enacted what's called the condo conversion law. And it's an act, chapter 527, that really regulates tenant rights as condo conversions happen. But it also affords municipalities the right to create further regulation. At the time this was enacted, a variety of communities went ahead and enacted bylaws. One of the towns that did so was Amherst. And Amherst did so on the basis of a comparison with the current vacancy in the rental market. What is the vacancy rate for units? And made it that if it was below 5%, you couldn't do any conversions unless it was a severe hardship. I can get to that in a second. And if it was above 5%, you could do it, and it would be a discretionary, but on a basis of a whole series of criteria. What this bylaw does is adopts the Amherst approach. It also, in addition, though, given the fact that this is a very complicated activity that you want to get right, and what state law provides is when you have an immediate issue, a problem so severe that you need to act immediately, and you don't have every single answer and you need some time to figure it out, but the time you take to figure it out, the operation was a success, the patient did die. So what you need to be able to do is you need to have some time to figure it out, so the law allows you to do a moratorium. And so this bylaw in Article 11, which does not require the state attorney general's, it does not require the legislature's approval, but does require the attorney general to take a look at it, provides a 2-year moratorium while the town looks at both implementing this bylaw and as well making whatever other steps we can make to help alleviate, and I don't think that in 2 years by any token, the housing crisis here will be alleviated, right? 30 years to get into a problem is not 2 years to get out. But whatever steps could be taken to further the action plan. So this would affect, one of the other unique aspects of the 1983 Act was that it affected all units built before 1983. That was the deal they struck. All units after 1983 were not covered by that law. And so Article 11 only applies to the pre-1983 units, which is, David, about 400.
No, 4 and more.
Yeah, 4, yes, that's right, I forgot the 4.
But yes. Applies to 334 units, I believe.
Right, 300, and 4 units and above, you're right, I forgot that point. Just as a side point, Article 12 we'd have to go to the state legislature, would bring it up to date to cover all of those 4 or more units above built up to today. So that's the difference between the two. Article 12 expands the coverage. Article 11 applies to pre-1983. That's essentially what this does. This also provides, after the 2-year moratorium, this provides a review. We can call it a hardship, but you need to look at Section 5 under the regulations. And you need to look at Section B, which says, in part, it's the third line under B. When the vacancy rate is equal to or lower than 5%, a building owner may not apply unless the financial or other circumstances for the owner are such that a prohibition of a conversion would constitute an unconstitutional confiscation of the owner's property. So if it's an unconstitutional taking because of financial circumstances or otherwise, then you'd be able to proceed. So there's essentially a hardship exemption. But that hardship exemption, as this is currently drafted, would come in after the 2-year moratorium.
So which board would be making that?
The Board of Selectmen.
Questions? Let's start with someone who, okay.
Well, I'm just, if you take one step back, pretend I'm a 5th grader,
Mm-hmm.
I still don't quite understand, like, what, all the words you said I understood, but I don't understand exactly what happens if this passes or not, like.
If this passes,
Yeah.
then all the units, 4 or more, built before 1983, about 340 units, I just want to keep getting in my head, that those units would, for 2 years, there'd be a moratorium on to converting them to condo. Then after that period, whenever the vacancy rate is above 5%, they'd be able to convert. When it's below 5%, they'd only be able to convert on a hardship based upon financial other consideration. And if Article 12 passed, that same circumstance would now apply to all units built up till today.
Yes.
Two questions. One, this only applies to currently, well, Article 11 applies only to buildings prior to 1983, and Article 12 applies buildings up to now. So none of this applies to empty lots, for instance.
No.
Well, no, but you can, if you're putting a moratorium on new condos, then you could in theory say new.
No, it's on the
condos.
conversion, not on new condos. It's on the conversion.
Okay. All right, another question I forgot about for a while.
We'll come back to you. Yeah.
So I have two questions. Units that are less than 4 are not affected by either of these.
Are not affected by it either.
Second question is, how is the vacancy rate calculated?
That's part of the discussion and part of the 2-year period. We should be getting to a validated approach. I think that, at least to the discussions that I've heard, that it really should be, the definition of vacant appears to be vacant and available for rent, as opposed to vacant, because vacant would include objects that aren't even on the market, and that would render the whole definition pointless.
Or
really,
seasonally.
right, exactly.
Which also shouldn't be.
Which also should be,
vacant.
right. And then, but I think there needs to be further discussion about that.
Back?
What constitutes 4 units? Is it 4 units in the same building? Could it be 2 buildings with 2 units in each? I mean, what constitutes 4 units?
It'd
It'd have to be on the same lot, yeah, I
On the
agree
same
with
lot.
Gloria, it'd have to be on the same lot.
Okay.
Do you remember?
Yes. And again, this is something because I'm new. Is there any appeal if after the Board of Selectmen rules on, let's say you're trying to get, you're claiming an unconstitutional breach, and the Board of Selectmen rules against you, can you appeal that?
Yes, I mean, and if it's if you have a constitutional claim,
The-
you can go all the way up to, our 9 justices
Got it.
down in DC.
What are some of the other communities in Massachusetts that have adopted this other than Amherst, and are any comparable to Provincetown? Like maybe the far west of Massachusetts. Where
If you
there's
have
a
one
lot
in
of
mind,
second
if you have one in mind.
No, I'm just saying like something like Stockbridge where they have a lot of second homeowners.
David?
So I don't know if I can recite the list. I
Any
think most
comparable
of them are
ones?
going, well, nothing's comparable, we already know that. So I think mostly all of them are around the Boston metro region. So Cambridge and Somerville and Brookline and Abington and New Bedford, Acton, 15, I think there's between 12 and 15, I don't recall the other communities. So I don't know that, again, any of them are necessarily, so Amherst, I think, is the opposite of us, so they're similar in the sense that it's a seasonal issue. Maybe Boston is too, because of all the universities, but obviously Boston is large enough that it can absorb that issue. So I think the reason why we looked at the Amherst model compared to the other 15 that we did look at was because most of them only address the tenancy rights issue. This addressed the inventory issue, and that's our concern. It's the evictions and the inability for evictions to find an alternative.
Tom?
So David, just to follow up on that, don't most of the other towns that are more like Provincetown, in fact, Truro, as an example, have a prohibition on year-round condominiums rather than having this permitting process? So rather than, this is a middle ground, most towns like in Western Mass do a prohibition, they just don't have condos. Truro's taken that path, as an example.
Well, Truro has condos.
But not
Their conversion bylaw.
So they're not,
had to do
they only have 3 seasons. Yeah.
Right, it had to do with the cottage colonies converting, but you can still have condos in Truro that are
But-
year-round even.
I wanna look that up.
Well, you can.
Let's get clear on
Are you done, Tom? You done?
Yeah.
So if this article passes and there's a 2-year moratorium, what would we like to see accomplished in that 2 years?
From my point of view, and I can just speak administratively, what I'd like to see is a couple things. I'd like to see clarity and community agreement on vacancy rate and how that's calculated and agreed, what's in the pool and what's not. Second, I'd like to see us move from what I believe to be we have a housing action plan, but if I was to really retitle that, I think it's a housing opportunity plan. And I'd like to see that converted into far more detail with a lot more understanding for the town related to the economics and the numbers, exact gap numbers. I'd like to see the special acts up in front of the legislature enacted, both the room tax applicability to many of these condominiums as well as to the trust fund. And I'd like to see the town being able to be in a better position to be able to execute on real estate acquisition and deal making, to be able to put housing in place, and movement on particular numbers for housing development on inclusionary zoning bylaw. All these things together and probably 4 more that I can't even think of, because this is not going to be it's not going to be a one silver bullet, nor is it going to be able to be solved in that period. But if we can get underway on a variety of fronts and start changing both the economics, the underlying economics, and also the tripwires, because this is a tripwire approach, which is useful, but at the same time, it's really a part of a puzzle, and the other part of the puzzle is really working on those underlying economics. So and again, that goes back to the special acts and the ability to execute. So while you can say it is the simplest thing is it's about getting the vacancy rate calculated, but at the same time, if all these were put in place, where you really want to be at, both articles, if both were put in place, is you want to be in a position that this succeeds if you can do a whole bunch of things that gets that vacancy rate above 5%. I mean, that's where we want to be, right? We want to be able to be in a place where the vacancy rate is above 5. And to get there, we need to be doing this and so much more. So this is a beginning, but in no sense is it the whole pie. That would be, if I was to ask, what am I looking, someone said to me, what are you going to do about this as the town manager after October 26th? That's what I'd like to do over the next 2 months after that, is put together with everybody that sort of an action plan. Sure.
Other questions?
Yes. A 2-part question. It relates to 5B. What methodology would the Board of Selectmen use to make their judgment? Whether it was an unconstitutional confiscation? And the B part, maybe Amherst has already answered this, is have there been any examples in Amherst of litigation around this?
There have been, and I did talk to Bob Ritchie, the general counsel from Amherst at the time this was done, and Bob also became the state assistant attorney general in charge of review of municipal bylaws. So he's kind of a good guy to ask. Bob basically said they were always able to work it out. There's been some pieces, but he really said that this is one that they've been over the course of time really been able to work with each of the developers. They haven't actually had, as far as he said to me, he did not recall that they'd have a constitutional crisis case that went up. I think you would look at you would look at C, but at the end of the day, what I would suggest, and I am not counsel for the town of Provincetown by any token, but I've done probably about over 200 eminent domain takings in my time, and there are clear legal standards for what is an unconstitutional taking, and what is a material diminution of value, and how that operates. But essentially, it's robbing the owner from any of their economic value or their play space, the direction they can go. So that would be what you'd wind up relying on. Lawyers.
Clear? Okay. Any other questions? All right. You need to say anything else about 12?
12 would just, as again as said, would have to go to the legislature for approval. And if it did, then it would extend the application to all units up until today.
And
Question.
there are models 12, like Amherst, just like their model.
No one has updated it as far as I know. I haven't checked. David, did you see? No. Sure. Which is really a flaw for many of those communities.
Sure.
Only one question. How many units are included in that closed session? You went all the way to current.
Over 1,400.
And that's only 4 units or more, or just,
It's 2 or more.
oh, 2 or more?
Anything else?
So it's not just,
Yeah.
so it's not just, the timing of when it was built. It also increases or decreases the number of units that it relates to.
I think that was the original draft. Is that what ended up in the final?
I
So on 12,
Do we change it from 4 to?
I don't, honestly, I
so
don't,
I think maybe.
I don't see that, David. At least
Yeah,
in
so
the
that didn't make the rewrite then, so it is still gonna be 4 or more.
yeah, 4 more.
Okay, great. So would that be 1,400?
No,
No.
it would be less, but we do have that number.
Okay.
Yeah, I thought that number was,
Originally, when we originally drafted it and did that analysis, it was 2 or more up to 2016.
Yep.
And so now that I am realizing that it didn't get included in the.
I don't know that it didn't, I think that we had discussion, David, and it was decided not to include it, but, yeah.
It's a simple extension.
I think it was a simple extension.
Yeah, we tried to simplify it
Yeah.
as much as possible,
Yep.
so, but we do have that number.
Cause I thought that number was more like 1,000, but we'll have that.
Makes sense.
Yeah.